So one type of intellectual property is unfair competition. More of this is addressed by state law than federal, but I just wanted to give you a few tips about what constitutes unfair competition. The idea of unfair competition is that we have a marketplace where we want companies to compete for your business, but we want them to compete according to the rules of the game. And part of the rules of the game are not being taking advantage of the other person or the other company rather. And so this picture kind of tries to show you, in a way, unfair competition, although you could argue that a little bit. But the guy on the left looks bigger, has larger arms, looks like he has larger muscles in his arms, and what you can see of the person on the right, their arms, their forearm is much smaller. So the idea that I'm trying to portray here is that although we do, as an economic system, support the idea of competition, the competition has to be fair. So how do you define that fairness? Well, one of the ways we define that fairness is that people do have restrictions on what they can do, and they can't just do anything they want. So the courts give a remedy if, for example, your way of competing, your company's way of competing, is by soliciting former employers, customers, or employees. So you worked for the company, you get a lot of the background and information, and then when you move, you solicit the customers of your previous employer, or you even solicit other employees to come work with you. And that is not considered fair competition, and there would be remedies that are available. Another type of remedy is when you're working for someone and you start another business and you start like using some of company time to build your business. You collect information and data from current customers so that you can use it in your new business. You collect information about policies or about the way business is done, and then you take that to use with your future business. That's considered unfair competition. On the other hand, if the employer wrongfully terminates you, um, that can constitute unfair competition depending on the reason for the termination. So that doesn't mean that everyone who gets fired has a claim for unfair competition. You have to look at the context, and if the competition, or the firing rather, was to, that's my granddaughter in the background if you hear the sneezing. Um, the idea is that if the employer terminates you as a way of getting a competitive advantage, then that can be a basis for unfair competition lawsuit. So let's take, for example, there's an iPhone on the left side of the screen, and then you make something that you call Jones iPhone, and that's what's on the right side of the screen. They look the same. They probably don't work the same because iPhone has certain technology internal to it, but I make one that looks like an iPhone and I call it a Jones iPhone, and therefore I can compete more in the marketplace for phones. Now, I know this is an old style phone, so just bear with me on the example. That would be an example of palming off, where you're trying to take advantage of all the goodwill that the existing company has and try to palm that off so that you can get some of that goodwill by making people think that what you've created is like the original. And that's considered unfair competition. So, other kinds of unfair competition would be anti-dilution statutes, which we talked about a little bit in the context of trademark. These are state laws that are designed to protect against non-competitors using a business's information or reputation or mark in a way that damages them, even though they're not competitors. So the idea is that if the use lessens the value or distinctiveness of the mark, then that's a violation of the state anti-dilution statutes, and therefore there can be remedies available. So let's take a look at what we've looked at in terms of types of intellectual property. So the column on the left, I want you to take that, one of the terms on the column on the left, and then match that with the column on the right. And I will give you about maybe 15 seconds to match those up, and then I'll show you the answers. Yeah, that's my granddaughter in the background. She's asleep now. But she has a cold, so it's kind of loud. Okay, so let's see what your answers are. Copyright, choreography is copyrighted or copyrightable. Patent, a hybrid plant. We talked about that in another session. Trademark, the golden arches would be an example of a trademark. Trade secret, KFC's secret recipe would be an example of that. And then unfair competition, palming off. So I hope that these set of videos helped you in understanding intellectual property more and better. Okay, I will see you online. Thanks for listening.